डॉक्टर बाबासाहेब आंबेडकर ओपन यूनिवर्सिटी.
Good evening, friends. Friends, I'm Dr. Dhaval Pandya. I welcome you all from the Chaitanya Institute of Dr. Babasaheb Ambedkar Open University. Today, we will learn about MBA's first SEM's one subject that is called Business Law. Code of the subject is MBA01C106, Unit number 1. Unit number 1 is a Indian Contract Act 1872. Friends, this unit is quite long one, so we have divided into two part. Today we are going to discuss about part 1, that is Indian Contract Act 1872-I. If we see the syllabus of this content of this unit, we can see we'll start from introduction to law, introduction to contract law, then classification of contract, offer and acceptance, then consideration, then capacity of parties, free consultation, and lastly legality of object. Okay, we'll start with introduction to law. As a social being, a man comes into contact with people in different capacities. He comes into contact, for example, with a landlord, as a tenant, with a government as a taxpayer, with customer as a seller, and with suppliers as a buyer. These contracts or associations are the inevitable consequences of modern civilization. In all this association, he is expected to observe a code of conduct or a set of rules. The object of these rules is to make human association possible and conducive to the welfare of the state and its people. Now, what is law? First, we should understand what is law. The word law is a general term and has different connotation for different people. Like 1, a citizen may think of law as a set of rules which he must obey. Second, a lawyer who practices law may think of law as a vocation. Third, a legislator may look at law as something created by him. 4, a judge may think of law as guiding principles to be applied in making decisions. Thus, a man's perspective influences his nation about law and as much is meaning. It is therefore not possible to give a single accurate definition of law. It is often preceded by an objective to give it a more precise meaning, like civil law, criminal law, mercantile law, industrial law, international law. However, in the legal sense with which we are concerned in this book, law include all the rules and practices which regulate our relation with other individual and with the state. The state regulates the conduct of its people by a set of rules It audience directly or indirectly, impartially or exponentially, a general cause of conduct to be followed by the people. Such rules of conduct, if recognized by the state and enforced by it on people, are termed as law. In this sense, Holland, a jurist, defines law as rule of external human action enforced by the sovereign political authority, like the state. In the word of Samold, law is the body of principles recognized and applied by the state in the administration of justice. Woodrow Wilson has defined law as the protein of the established habit and truth of mankind, which has gained districts and formal recognition in the shape of uniform rule backed by the authority and power of the government. In presence, uh, it represents a code of conduct which is established and enforced by the state of law. In this sense, has a twofold aspects. It is an abstract body of rule and also a social machinery for securing order in the community. Law is not static as circumstances and conditions in a society changes. Laws are changed to fit the requirement of the society. As such, law preventing in a society at any point of time must be in conformity with a general sentiments, customs, and aspiration of its people. It is a living phenomenon having a real existence in relation to the fact of human affairs. Now, need for the knowledge of laws. Need for the knowledge of law. Ignorantia juris not execute as a familiar maxim. This means ignorance of law is not excused. Although it is not possible for a layman to learn every branch of law, yet it is to the advantage of each member of the community to know something of rules and regulations by which he is governed, and as such he must acquaint himself with the general principles of the law of the country. This branch of law, known as mercantile law or commercial law or business law, is of particular importance to people engaged in the economic and commercial activities. The term mercantile law is used to denote that branch of law which is concerned with such matters are as usually the subject of what may be called mercantile transactions. It deals with contractual situation and the right and obligations arising out of mercantile transactions between mercantile people. A mercantile person may be a single individual, a partnership, or a joint stock company. The term mercantile law is also used to denote the aggregate body of those legal rules which are connected with trade, industry, and commerce. After this, we'll see the introduction to contract law. Introduction to contract law. On a daily basis, we enter into lots of transaction, who from buying toothpaste to paying bills in hotels. To satisfy our daily wants and desires, we enter into agreements which may be oral or written, expressed or implied, which all rules in contracts. The Indian Contract Act 1872 is an act which specify the deals with the principles of the law of contract. The act was entered on 25th April 1872 and subsequently came into force on the first day of September 1872. It is important to note here that ever since this act enactment of this act in 1872, it has never been amended, and thus the law that was made back in 1872 still stands good. So it shows that importance of this act. The act was passed by British Indian and is based on the principles of English common law. This act described different stages in the formation of a contract, its performance, essential elements, breach of contract, and remedies for the breach of contracts. The act deals with a number of limiting principles, subject to which the parties to the contract may create certain right of duties for themselves. Now, source of mercantile law. What are the source of mercantile law? These four are the source of mercantile law. The bulk of the Indian mercantile law is based on this four. The English mercantile law, in the absence of any specific law, usage or custom on a particular point arising before a court. Rules of the English law, that of justice, equity, and good consequences are applied. The courts in India are, however, selective in the application of English law. The source of the Indian mercantile law are these are the source of English mercantile law. First, English mercantile law. This is the most important source of the Indian mercantile law. The principal source of the English mercantile law is common law of England and modified and supplemented by equity and statute law. Second one is statute law. The Contract Act 1872, the Sale of Goods Act 1872. In 1930, the Partnership Act. 1932, the Companies Act. 1956 are intents of the statute law. In India, bulk of mercantile law is statute law based largely on the English law. The law-making power in India is vested in the parliament and the state legislature. Third one is the judicial decisions or the system of uh, precedent precedence. This is a source of law based upon previous jurisdiction decisions which have to be followed in similar future cases. The system of precedence has been described as a system of law which applies in new combination of circumstances those rules which are uh, described from earlier uh, judicial decisions. Fourth one is custom and usages. Custom and usages established by the long use and constantly put into practice become binding on the parties entering into commercial transportation. Custom in order to be bring on the parties must be ancient, responsible, certain, definite, consistent with other customs, and unfortunately recognized in the ordinary course of business, like CINB syndicate, Ramchandra AIR 1968, Myers 133. When a custom is accepted by a court and is incorporated in the judicial decisions, it becomes a legally recognized custom. Now, object of the law of contract. Object of the law of contract. Object of law of contract. The law of contract is that branch of law which determines the circumstances in which promises made by the parties to a contract shall be legally binding on them. It is rules define remedies that are available in the court of law against the person who fails to perform his contract, and the conditions under which the remedies are available. It is the most important branch of business law. It affects all of us in one way or the other. It is, however, is of particular importance to people engaged in trade, commerce, and industry. The law contract introduce definiteness in business transaction. Sir Williams Anton observed in this connection that the law contract is intended to ensure that what a man has been led to expect shall come to pass, and that what he has been promised shall be performed. In simple words, it is may be said that the purpose of the law of contract is to ensure the realization of reasonable expectation of the parties who enter into a contract. Now, coming to the first point, legal bind. One of the primary purpose of the objective of law contract is to bind people by the law when they get into an transactions. It determines the circumstances in which promises made by the parties to a contract shall be legally binding on them, both the parties. Second, provided legal remedies. The law of contract provides legal remedies as and when needed by the parties to get into contracts. Every commercial transaction, by its every nature, is a legal contract and is legally binding into the parties to it. In case of any breach of violation of the promises made by either of the parties, the law can intervene and provide legal solution to the parties if sought so by any of the parties to the contract through the court. Third one, universal application. The law of contract is one of the most important branches of business law, and it affects all of us in one or other way through it is of particular importance to people engaged in the trade, commerce, and industry. When any person get into a transaction with another person, they are by default involving this branch of law in it. When one buys a packet of biscuits from a provision store, or when a person board a bus, or when one buy or sell in the property, this branch of law is evolved. Now, fourth one, definiteness. The law of contract does not define how a contract should be done, but it lists down a few do's and don'ts about every transaction, which brings about a definiteness in transactions, whether related to business or otherwise. 5. Social and economic justice. Social and economic justice. In our society, law serves as a medium of change and as a harbinger of social justice. A great part of law is designed particularly to bring about all the citizens individually and collectively. The law of contracts tries to bring out uniformity in the transaction and the dealing of the people within the society. After this, we will see about feature of the law of contracts. Feature of the law. There are 7 features. Oh my God. Okay. First one, the act is not executive. The act is not executive. The Indian Contract Act does not provide to be complete and exhaustive code. It deals with the general principles of contract and with some special contracts only. The law of contract differs from these branches of law in an important respects. The law contract does not define precisely of to parties as to how a contract is to be done. It is rather demarcate certain do's and don'ts, or which can be defined as limiting factors within which the parties to a contract are supposed to create a contract. As long as parties to a contract do not interfere in this set of prohibition, they are free to create any contract and terms of contract as they feel free. This means that the parties to the contract create the law for themselves. They can make the rules they like in respect of the subject matter of the agreement and the law which gives effect to their decisions. Now, second, the law of contract is not the whole of agreement nor the whole law obligations. There are several engagements which do not give rise to legal obligations. They are therefore not contracts. Similarly, they are certain obligations which do not necessarily spring from an agreement, like, for example, civil wrong questions, judgment of court, etc. Salmon has rightly observed that one of the experts, Salmon, has rightly observed that the law contract is not a whole law of agreement or the whole law obligation. It is the law of those agreement which create obligations and those obligations which have their sources in agreement. It is excludes from its purview all those obligations which are not contractual in nature and agreement which are social in nature. Now, third one, law of contract creates jus in personam as distinguished from jus in rem. Jus in rem means a right against or in respect of the thing. Jus in personam means a right against court in respect of a specific person. A jus is rem is available against the word at large. Jus is personam is available only against a particular person. Now, fourth, agreement and its enforceability. If we analyze the definition of a contract, we find that a contract essentially consists of two elements. One is an agreement, and second one is its enforceability by law. An agreement is defined as every promise and every set of promises facing consideration, forming consideration for both the parties or each other. When the person to whom a proposal is made silently his assent there to the proposal, it is to be accepted. A proposal, when accepted, become a promises. This, in other word, means that an agreement is an accepted proposal. To form an agreement, this must be proposal or offer by one party and it's accepted by the other one. To sum up, agreement is equal to offer plus acceptance, we can say. Now, fifth one, consensus and idem. The essence of an agreement is the meeting of the mind of the parties in full and final agreement. This must, in fact, be consensus ad idem. The order could be an agreement between two parties that must be consensus ad idem. This means that the parties to the agreement must have agreed about the subject matter of the agreement in the same sense and at the same time, unless there is consensus ad item, there can be no contract. Sixth one, obligation. An agreement to become a contract must give rise to a legal obligation or duty. The term obligation is defined as a legal tie which imposes upon a definite person or persons the necessity of doing or abstaining from doing a definite act or acts. It may relate or social or legal matters. An agreement which gives rise to a social obligation is not a contract. To rise to a legal obligation in order to become a contract. Now, the seventh and the last one is agreement in a very wide term. An agreement may be a social agreement or a legal agreement. If if we look into it by A and B, to A invited B to a dinner and B accepts the invitation, it is a social agreement. A social agreement does not give rise to a contractual obligation and is not enforceable in a court of law. It is only those agreements which are enforceable in a court of law, which are contracts. If we say into if we conclude, contract is an agreement plus enforceability by law. Okay, so here we conclude our stop our lecture, today's lecture. How many questions can we ask from this unit, this lecture rather? So first it can be what is law, discuss in detail. Second one is what are the sources of mercantile law, describe in detail. Third one, what is the law of contract, describe its feature in detail, feature of law. What is legal bind? In short notes or short question it can be asked. What is legal bind? What is social and economic justice? So these are few long questions, short questions and short notes. So we'll continue this lecture in next session also, and continue this unit in next lecture. Till then, goodbye and take care. Namaskar.
स्वाध्यायः परमं तप